I agree with the statement, the Commerce Clause, the secret weapon of Congress. In the 13 years between the Declaration of Independence in 1776 and the adoption of the Constitution in 1789, the U.S. was governed primarily by the 13 states. Because state legislatures controlled their own commerce, the federal Congress was unable to enter into credible trade agreements with foreign powers to open markets for American goods. The result of this was a nationwide economic downturn. In 1787, political dissatisfaction with the economic situation led to the Constitutional Convention in Philadelphia. The new Constitution proposed the Commerce Clause, which grants Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. This gave Congress the power to regulate interstate commerce. It enabled the creation of a free trade zone and gave Congress the power to approve treaties to open foreign markets to American-made goods. Congress has often used the Commerce Clause to justify exercising legislative power over the activities of states and their citizens, leading to significant and ongoing controversy regarding the balance of power between the federal government and the states. The Commerce Clause has historically been viewed as both a grant of congressional authority and as a restriction on the regulatory authority of the states. The meaning of the word commerce is a source of controversy, as the Constitution did not explicitly define the word. Some argue that it refers simply to trade or exchange, while others claim that the framers of the Constitution intended to describe more broadly commercial and social intercourse between citizens of different states. Thus, the interpretation of commerce affects the dividing line between federal and state power. Moreover, what constitutes interstate commercial activity has also been subject to consistent debate. From the founding until today, the Supreme Court definition of commerce has not changed much. It was expanded in 1944 when the Supreme Court held that commerce included a business such as insurance in U.S. v. Southeastern underwriters. The modern growth of Congress's regulatory powers has been allowed by the courts adopting an expansive reading of the necessary and proper clause to give Congress power over a broad range of interstate economic activities with a substantial effect on interstate commerce. As the New Deal Supreme Court said in U.S. v. Darby in 1941, the power of Congress over interstate commerce is not confined to the regulation of commerce among the states. They explained that while manufacture is not of itself interstate commerce, the shipment of manufactured goods interstate is such commerce, and the prohibition of such shipment by Congress is indubitably a regulation of the commerce. As also stated in that case, Congress's power also extends to those activities intrastate which so affect interstate commerce or the exercise of the power of Congress over it as to make regulation of them appropriate means to the attainment of a legitimate end, the exercise of the granted power of Congress to regulate interstate commerce. In 2005's Gonzalez v. Raich, Justice Scalia wrote that Congress may regulate even non-economic local activity if that regulation is a necessary part of a more general regulation of interstate commerce. In Quilcor versus North Dakota, the Supreme Court concluded that obliging an individual retailer to comply with the rules of what were then more than 6,000 separate possible sales tax jurisdictions, which is a number that has now grown into the 5 figures, would be so burdensome that it would be a de facto restraint on interstate trade. When there are strong interest groups on both sides, as is in the case of Quill, Congress is often paralyzed. In short, Quill imposes fiscal and dignitary harms on states without any real hope that these injuries will spur legislative action. And because internet trade is becoming so large now, I'm sure we are going to be seeing more cases similar to this. Congress's power is not unlimited, however. In 1819's McCulloch versus Maryland, Chief Justice Marshall wrote that should Congress, under the pretext of executing its powers, pass laws for the accomplishment of objects not entrusted to the government, it would become the painful duty of this tribunal to say that such an act was not the law of the land. In 2012's NFIB v. Sibilis, a majority of the Supreme Court found that a mandate to compel a person to sign up for health insurance under the Affordable Care Act was beyond the powers of Congress. Wrote Chief Justice Roberts, that clause authorizes Congress to regulate interstate commerce, not to order individuals to engage in it. The dormant Commerce Clause refers to the prohibition implicit in the Commerce Clause against states passing legislation that discriminates against or excessively burdens interstate commerce. Of particular importance here is the prevention of state policies that favor state citizens or businesses at the expense of non-citizens conducting business within that state. For example, in Westland Creamery v. Healy in 1994, the Supreme Court struck down a Massachusetts state tax on milk products as the tax impeded interstate commercial activity by discriminating against non-Massachusetts citizens. And as shown in all of these cases, Congress has the power to oversee commerce throughout the United States.